In October 2025, the UK will begin enforcing new deportation rules, so strict that even a missed renewal date, an unpaid hospital bill, or a minor traffic offence could be enough to send someone out of the country. These 10 rules will shock you, and they could affect far more people than you think. Number 10. National Interest Clause. Perhaps the most far-reaching and controversial rule taking effect in October 2025 is the so-called National Interest Clause. This provision grants the Home Office the authority to deport individuals deemed a potential risk to the UK's security, stability, or reputation, even if they have committed no formal crime. The language of the clause is deliberately broad, covering anyone whose presence is considered contrary to national interests. While officials claim it will be used sparingly against those linked to terrorism, espionage, or serious organised crime, critics fear that the vague definition could be stretched far beyond its original intent. The implications for ordinary migrants are deeply unsettling. Under this rule, someone involved in protests, online activism, or political criticism of the government could be targeted if their actions are perceived as disruptive. A journalist exposing controversial issues or a community leader advocating for migrant rights may find themselves flagged under the guise of national security. Without the need for a criminal conviction, deportations can occur based on suspicion, intelligence reports, or internal assessments that are rarely transparent to the public. This creates a system where migrants live under constant risk of being judged, not only for what they do, but for how the state interprets their influence. Civil liberties groups argue that the National Interest Clause undermines fundamental rights, such as free speech and peaceful assembly. They warn that it creates a chilling effect, discouraging migrants from engaging in political or social debates out of fear their voices may be used against them. Legal experts point out that appeals will be limited, as national security cases often involve classified evidence unavailable for review. For migrants, this rule means that even a spotless record and full compliance with all other laws may not guarantee safety from deportation. The broad power given to the Home Office essentially places every migrant under conditional acceptance, with the looming threat that their future in the UK can be revoked at any time, if deemed inconvenient to the state's interest. It is this unpredictability that makes the National Interest Clause one of the most alarming aspects of the new deportation framework. Number 9. Fake documentation. Starting in October 2025, the UK will enforce a zero-tolerance policy toward the use of false or misleading documents in immigration and employment processes. Anyone caught presenting forged passports, altered work permits, or counterfeit residency papers will face immediate deportation, accompanied by a 10-year re-entry ban. Even seemingly minor infractions, such as exaggerating employment records or misrepresenting study credentials, may be considered fraudulent under the new rules. The government has stated that advanced biometric systems and document verification tools will make it far easier to detect irregularities, ensuring that very few slip through unnoticed. This policy is aimed at deterring individuals who exploit loopholes or attempt to stay in the UK under false pretenses. Yet critics argue that the rule casts too wide a net, placing genuine migrants at risk if they unknowingly submit documents that contain errors. For example, recruitment agencies or third-party visa consultants sometimes provide applicants with misleading paperwork, often without their knowledge. Under the new framework, the burden of responsibility falls entirely on the migrant, regardless of whether they intended to commit fraud. A student whose agency altered a certificate without their consent, or a worker who unknowingly receives a forged permit, may still face deportation under the same harsh measures. The consequences of this rule extend beyond immediate removal. A 10-year re-entry ban means individuals deported for documentation issues will be excluded from returning to the UK for an entire decade, regardless of whether they later secure legitimate opportunities. Families could be permanently separated and careers cut short, all due to a single error or misstep in paperwork. Human rights groups warn that this approach prioritizes punishment over fairness, leaving many with no path to appeal or clear their names. The government's message, however, is uncompromising. Document integrity is now at the heart of immigration enforcement. For migrants, the implication is clear. Every form, certificate, and permit must be flawless and verifiable, because even the smallest irregularity can trigger deportation and lock the door to Britain for years to come. Number 8. Health and NHS access violations. From October 2025, unpaid healthcare bills will carry far heavier consequences for migrants living in the UK. Under the updated rules, anyone with outstanding NHS debts of more than £500 can now be targeted for deportation. Previously, these debts could damage future visa applications or limit certain services, but they did not always lead to immediate removal. The new framework makes it clear that unpaid medical costs will be treated as a violation of immigration law rather than just an administrative issue. This shift reflects the government's intent to frame healthcare misuse as both a financial and legal breach, placing vulnerable groups directly at risk. This policy disproportionately affects individuals who have limited access to private insurance or who face unexpected medical emergencies. A single accident, hospital stay, or surgery can push bills above the £500 threshold in a matter of days. Migrants without stable incomes may struggle to pay quickly, and many may not even realise that their bills are accumulating. For those on student or temporary work visas, these costs can easily spiral out of control, especially when medical needs intersect with housing, tuition, and other financial pressures. Once flagged, the debt does not simply prevent further services, it becomes a basis for deportation proceedings, cutting short lives and careers in an instant. Critics point out that this rule could deter migrants from seeking medical help altogether, leading to dangerous public health consequences. People may avoid hospitals, clinics, or even basic checkups for fear of accumulating charges that could endanger their right to stay. This avoidance could worsen treatable conditions, increase the spread of communicable diseases, and strain emergency services when issues eventually become critical. Human rights organizations argue that access to healthcare should never be weaponized as an immigration control tool, yet the government insists that taxpayers should not bear the cost of unpaid bills. For migrants, the result is a stark choice: either pay immediately and fully for healthcare, or risk losing everything. The rule sends a chilling message that even life-saving treatment, if left unpaid, can become the very reason for being forced out of the country. Number 7. Breach of public funds restrictions. One of the most overlooked yet serious risks for migrants in the UK will be tied to public funds. From October 2025, anyone who accesses benefits or state assistance they are not entitled to will face automatic deportation. This includes housing support, unemployment payments, child benefits, or pensions reserved strictly for citizens and permanent residents. Even unintentional claims, such as a misunderstanding of eligibility or a clerical error during application, may now be enough to trigger enforcement action. For migrants, this transforms the benefit system into a legal minefield, where even small mistakes carry life-changing consequences. The reasoning behind this change is rooted in government claims of protecting taxpayer resources and ensuring that social support is reserved for those with full citizenship rights. However, the scope of what counts as public funds is broader than many migrants realise. Accessing subsidised housing, claiming rebates, or even relying on certain emergency payments could be flagged as a breach. Families struggling with rising rents and living costs may inadvertently cross these lines, not out of deception, but desperation. With living expenses soaring, some migrants may take risks to secure financial stability, unaware that one application could set off a chain of events, leading directly to removal. Critics argue that this policy unfairly targets the most vulnerable, particularly low-income households already struggling to survive in the UK's expensive economy. It also risks punishing children who rely on benefits for basic needs, as their parents' actions could determine the family's deportation. Advocacy groups warn that migrants may become too afraid to seek legitimate help, even in cases of crisis, for fear of accidentally breaching benefit restrictions. The chilling effect could leave many without shelter, food, or medical support, pushing entire communities into deeper poverty. By tying access to benefits directly to deportation, the UK government is effectively drawing a hard line between citizens and migrants, framing survival decisions as legal violation. For migrants, the message is unambiguous. No matter the situation, crossing into the realm of public funds without explicit entitlement will be treated as grounds for removal, making financial hardship a direct path to expulsion. Number 6. Lack of digital ID compliance. October 2025 marks the rollout of the UK's new digital immigration ID system, a centralised platform designed to track the status of every migrant in real time. Every visa holder, student, worker, or asylum applicant will be required to register and maintain up-to-date information through this system. Failure to comply, whether by missing a deadline, not uploading required documents, or neglecting to renew details, will now be classified as grounds for deportation. Unlike previous paper-based processes, the digital system leaves little room for flexibility. Automated alerts will flag any lapse immediately, triggering potential enforcement action without the long delays migrants were once accustomed to. For many migrants, this new requirement will be a major challenge. Not everyone has equal access to digital tools, reliable internet connections, or the technical literacy needed to manage an online immigration profile. Elderly migrants, low-income workers, and individuals from communities with limited digital infrastructure are at particular risk. Even small errors, like an incorrect spelling, a missed notification, or a technical glitch, could have devastating consequences. Once flagged as non-compliant, migrants may find themselves quickly placed on a removal list, regardless of how long they have lived or worked in the UK. Critics fear that the system's reliance on automation will strip away human judgment, punishing individuals for administrative mistakes rather than willful disobedience. Government officials defend the system as a step toward modernization, arguing that it will reduce fraud, cut down on paperwork, and make enforcement more efficient. Yet human rights advocates argue the opposite, that the digital system could become a surveillance tool, turning migrants into data points, constantly monitored for errors. Families who forget to update a simple change of address may be caught in the dragnet, facing life-altering deportations for minor oversights. This rule signals a shift in policy focus from intent to compliance, meaning that even honest mistakes will no longer be excused. The introduction of digital IDs will fundamentally change how migrants interact with the UK government, forcing them into an environment of constant vigilance, where one overlooked notification can decide whether they remain or are removed. Number 5. Dependents of deported individuals. A controversial new measure, taking effect in October 2025, extends deportation risk beyond the individual directly involved to their family members and dependents. Under this framework, when a person is ordered to leave the UK, their spouse, children, or other registered dependents may also be compelled to depart, regardless of whether they have a partially valid or separate status. The government argues that this is necessary to prevent split households and to ensure compliance with deportation orders. Yet for many families, this will mean facing sudden upheaval and forced relocation, even for members who may have done nothing wrong. Imagine a child born in the UK to migrant parents. Even if that child has begun school and is thriving in the local community, their connection to a parent under deportation could lead to removal for the entire household. Similarly, a spouse who has legal permission to remain through work or study may still be affected if their partner is ordered to leave. This rule creates a domino effect, where the fate of one person directly decides the destiny of several others. Human rights organizations warn that children will be the most vulnerable, often being forced to move to countries they have never known, losing access to healthcare, education, and the social networks that define their lives. Critics see this as collective punishment, arguing that deportation should be handled individually, not applied across entire families. They also highlight the emotional trauma caused by such removals, as many dependents will have deep roots in the UK after years of integration. Legal experts caution that this approach could face challenges under international law, particularly conventions on the rights of the child. Nevertheless, the Home Office insists it will press forward, framing the policy as a deterrent against overstays, visa fraud, and illegal work. For families, the reality is tech. A single misstep by one member could drag everyone into deportation proceedings. The result is a climate where dependents must live under the shadow of uncertainty, knowing that their security in the UK is no longer determined solely by their own actions, but by the decisions or circumstances of those closest to them. Number 4. Failed asylum seekers. From October 2025, asylum seekers whose claims are rejected twice will face an automatic removal order, closing a door that previously allowed for lengthy appeals and case reviews within the UK. Under the older framework, individuals could often challenge decisions multiple times, especially if new evidence or changing country conditions supported their claim. That pathway is being restricted sharply. Now, once the Home Office issues 2 refusals, the individual will be scheduled for deportation without the option of further appeals while remaining in Britain. The stated goal is to reduce the backlog of asylum cases, but the human impact will be profound, as thousands could find themselves out of options almost overnight. This rule particularly affects people from war-torn or unstable regions, where evidence is difficult to gather, and shifting conditions on the ground can alter the safety of return within months. A rejected claim does not always mean the applicant is safe in their home country, yet the new law treats it as final. Human rights advocates warn that this rigid system risks sending people back to dangerous situations. Even applicants with families, children in school, or ongoing medical treatments will be forced to leave quickly, often with only a few weeks' notice. Airlines and border agencies will be required to cooperate fully, reducing the chances of individuals resisting deportation or seeking last-minute legal remedies. The broader effect will be a chilling one. Migrants may avoid applying for asylum altogether, fearing that a failed attempt will fast-track their removal. Communities and charities that provide shelter to asylum seekers are already voicing concerns that people will be driven underground, choosing to remain hidden rather than risk entering a system stacked against them. For families who have spent years waiting in the UK while their cases are processed, a second rejection will mean the abrupt end of any hope of staying. By limiting appeals and accelerating removals, the UK government is effectively declaring that the asylum process is no longer about protection, but about swift enforcement, reshaping Britain's reputation as a refuge into that of a strictly regulated border state. Number 3. Criminal convictions of any kind. Beginning in October 2025, the threshold for deportation due to criminal convictions will be dramatically lowered, meaning thousands could find themselves at risk of removal for offences once considered too minor to trigger such measures. In the past, deportation was largely reserved for individuals guilty of serious crimes, such as violent assaults or organised fraud. The new rules, however, widen the net to include far less severe infractions. Repeated traffic violations, shoplifting, or even a single charge of public disorder could now form the basis for deportation proceedings. The government frames this as a zero-tolerance approach, designed to emphasise that any breach of the law undermines an individual's right to remain in the UK. This change is especially concerning because many offences that fall under the expanded criteria carry small fines or short custodial sentences. A migrant who struggles with paying a fine on time, or who accumulates points on a driving licence, may suddenly face life-altering consequences. Families may be torn apart because of what might otherwise be a routine legal issue for a British citizen. Immigration lawyers warn that this system creates a double standard. Citizens and migrants committing the same act will face vastly different outcomes. While a citizen may walk away with a warning, a migrant risks not only punishment, but also forced removal from the country. The scale of this disparity has already drawn criticism from human rights groups, who argue that the rules strip migrants of equal protection under the law. Critics further note that this policy could intensify profiling and selective enforcement. Police and border agencies may prioritise migrants for surveillance, leading to an environment where even minor missteps are documented and escalated. For those already living in uncertainty about their status, the fear of deportation for small mistakes will create a climate of constant anxiety. Community organisations have pointed out that such measures may discourage migrants from reporting crimes or seeking help, as any interaction with law enforcement could expose them to removal. By broadening the definition of deportable crimes, the UK is signalling that migrants must live under a stricter code of behaviour than the citizens around them, with far harsher penalties for slipping outside the lines. Number 2. Employment without authorisation. One of the most significant changes coming in October 2025 is the harsh treatment of anyone caught working without proper authorisation. The UK government has made it clear that unauthorised employment will no longer be treated as a minor administrative violation. Instead, it will be handled as a major breach of immigration law, leading directly to deportation. This includes people who work beyond the permitted hours of a student visa, take on second jobs outside their visa restrictions, or even volunteer in roles that could be considered work-like by the authorities. For many migrants, this rule creates a dangerous trap. What seems like harmless extra income or community involvement could suddenly become the reason for losing their entire right to remain in the UK. The pressure will not only fall on the workers, but also on the businesses that employ them. Employers will face larger fines and potential criminal charges if found hiring unauthorized staff. However, the law is written in a way that prioritizes the removal of the worker over the punishment of the employer. Once a violation is detected, deportation orders are issued swiftly, leaving the individual with little chance to argue their case. Cases have been reported where workers believed their documents were valid, only to discover that their employer had not processed them correctly. Under the upcoming system, those workers will carry the full burden of responsibility, regardless of whether they intended to break the rules or not. This shift will be particularly devastating for migrants in low-wage sectors such as agriculture, hospitality, and care. Many of these individuals fill roles that locals are unwilling to take, yet they will be the first to face removal if paperwork is not perfectly aligned. Critics argue that the government is using migrants as scapegoats for labour market pressures, while ignoring the structural reliance on their contribution. For migrants, the message is chillingly clear. If you are not fully authorised, every shift, every paycheck, and every task puts you one step closer to deportation. The promise of opportunity in the UK is being reshaped into a strict legal minefield, where one mistake at work can erase years of effort and sacrifice. Number 1. Stricter visa overstays. Starting October 2025, the UK government will introduce a far tougher stance on visa overstays, a change that could impact thousands who have built their lives quietly in Britain. Previously, those who stayed past their visa deadline were often given some leeway, sometimes weeks or even months, to either renew their documents or prepare to leave voluntarily. That buffer is now being erased. Under the new framework, even a short delay of a few days may trigger an automatic deportation notice. The Home Office has stated that a 14-day maximum correction window will remain, but after that, overstayers will be treated as having no legal right to remain in the country. This new rule will create ripple effects for workers, students, and families who may miss a renewal deadline because of paperwork delays, financial constraints, or simple misunderstandings about the system. Migrants who rely on seasonal jobs or short-term academic programs are particularly vulnerable, since their visas are often issued with rigid timeframes. Imagine a student who finishes exams but lingers briefly to attend graduation ceremonies, or a care worker who extends their stay for a final shift before heading home. Situations like these, once treated with some flexibility, will now be grounds for forced removal. Airlines may even be alerted to deny boarding passes if a person is flagged in the overstayer database, leaving individuals with no chance to resolve the issue on their own. The government argues that the stricter policy will free up housing, jobs, and public resources by removing those without valid leave to remain. Critics, however, warn that this measure could criminalize honest mistakes, trap families in sudden crises, and create an environment of constant fear among legal migrants. They point out that renewal systems are often backlogged, with processing times stretching far beyond the visa expiry date, meaning many people risk deportation despite having already applied for extension. The effect will be a Britain where every migrant must monitor dates with military precision, knowing that even a brief overstay, whether intentional or accidental, will be enough to uproot their entire life and send them back, often with no right to appeal. The deportation rules, set to begin in October 2025, mark one of the most sweeping overhauls of the UK's immigration system in recent history. From stricter visa overstays to the controversial National Interest Clause, each new measure carries the potential to alter thousands of lives. For many migrants, the smallest mistake, whether a missed deadline, an unpaid bill, or an error in paperwork, could mean the end of years of effort spent building a life in Britain. What makes these changes particularly alarming is how they extend beyond individuals to families, communities, and even entire support networks. Dependents of deported individuals, asylum seekers facing sudden removals, and workers in low-wage sectors will all feel the weight of these rules most directly. Critics argue that the system places migrants under constant surveillance, forcing them to live with the fear that any misstep could lead to removal. This climate of uncertainty is reshaping what it means to be a migrant in the UK, replacing hope with caution. Ultimately, these rules reflect more than just administrative tightening. They symbolize a shift in how the nation views those who come seeking opportunity, safety, or a better future. The question now is how many lives will be disrupted once October arrives.